Welcome to The Fine Print, the podcast where we explore the law, its impact, and the people who shape it. I'm your host, Rudelle, and on today's episode, we're joined by Mr. Kevin Chan, a leading director at Clyde & Co. and an accredited specialist in maritime law. He's an expert in shipping, commodities, and international trade disputes, and has worked with clients around the world on complex, high-stakes cases. Mr. Chan also contributes to top legal publications, offering his expert insights into the ever-evolving world of maritime and commercial law and giving listeners a front-row seat to this fascinating, fast-moving field. So, to start us off, what first drew you to specialize in maritime law, particularly shipping and commodities?
I think to start off, thanks Rudelle for inviting me to be part of this podcast. I've got to be frank, I wasn't someone with lofty aspirations to, save the world and do justice or fight for justice. I think growing up, I was your typical student in Singapore. I did reasonably well in school. I had absolutely no idea what I wanted to do. And back then, the career advice from people of our parents' generation was this: you study hard, you get good grades, and you do either medicine or law. The problem was that I couldn't stand the sight of blood or dissected body parts. So I guess law was the only survivable option for me. So when I started studying law at NUS, what really was the realization that, it's never usually just black and white. There are a lot of gray areas in the law, even when legal authorities may seem very clear-cut. Their application to different factual scenarios tend to be quite different. And what really appealed to me was, the intellectual challenge, the constant navigation through murky waters, and the need to strategize in order to advance your own case. And I think in cross-border disputes, it is even more complex. Every country has its own laws, its own legal systems. I even put it as quirks, its own sense of what is right, wrong, and fair. And I found it fascinating, which ultimately led me to explore a career in maritime law, a field that is, by nature international. Cargo, people, ships, they cross borders, they cross oceans, and I don't think there's anything that can get more international than maritime law.
So thank you for sharing your journey and how you were kind of inspired by this international and global aspect and appeal of maritime law. So for listeners who may not be too familiar with maritime law, how do shipping and commodities disputes typically differ from other types of commercial or civil disputes?
If we are talking about usual shipping disputes, your charter parties, your bills of lading, your sale of goods disputes, most of them tend to end up arbitration. Why? You are going to ask me next. Because parties tend to value confidentiality. They want autonomy in choosing how their disputes are to be resolved, and since they are usually of different jurisdictions, shipping being international in nature, they prefer, or I would say they tend not to want to submit to the national courts of either one parties. But I must admit that it is a little bit of an oversimplification. In reality, we as maritime lawyers rarely stick to the very neat little boxes of charter parties and bills of lading. We deal with whatever the shipping industry throws at us. For example, we might need to dip our toes into company law if we are asked to advise a company on whether its directors had overstepped boundaries or breached any statutory duties. We might have to deal with banking law when we deal with ship mortgages, financing, and insolvency law also crops up very frequently in maritime and shipping. For instance, an example, you might be asked to advise on whether you can arrest a vessel chartered by a company which is insolvent and where there's a statutory moratorium in place. And sometimes, this might be interesting also, that you might even touch a little bit on criminal law. For instance, if a vessel is forfeited because the crew was smuggling prohibited items like cigarettes. So the one word I would describe it is multifaceted, which we are looking at when you talk about shipping and maritime law.
Yeah, that offers a lot of clarity on the area of maritime law. Having it just be present in so many facets, as you mentioned, multifaceted, kind of shows your role as a lawyer and how your expert skills are needed in many different areas. So delving a bit deeper and on a more global perspective, you mentioned that shipping is international in its nature. So how do you navigate differing jurisdictions and legal cultures?
I think you are absolutely right. Shipping is inherently international in nature, like what I mentioned. So it is very rare that we deal with just one jurisdiction. I would almost never see a case where you deal with a shipment from Sembawang Port in Singapore to Pasir Panjang in the south. So I think the answer to this is really appreciating the need to collaborate with lawyers from multiple jurisdictions on any matter. So it might be helpful for me to perhaps at this juncture give illustration. So you are a Singapore ship owner and you charter out your vessel to carry coal on multiple shipments from, say, Kalimantan in Indonesia to Rayong in Thailand. What then happens is that market conditions change after the charter parties entered into freight rates drop, and the charterer suddenly refuses to pay freight, and they push the blame on you, citing problems like engine breakdown, contaminated hulls, so on and so forth. And they may even say that you are the one who are liable to pay them damages instead of them paying you freight. So I think it's clear that the dispute under the charter party itself would be determined based on its dispute resolution clause. And it is more often than not governed by English law, with arbitration seated in Singapore, England, New York, Hong Kong. But I think we need to be alive to the fact that that forms only a part of the bigger picture. As the ship owner, you might want to exercise something we call a lien over the cargo to secure payment. And that usually entails working with local lawyers in the jurisdiction where you're going to discharge the cargo. In the hypo I gave over here at the Thailand, to see that, I think to really explore two things. Number one, whether you are entitled to exercise this lien in the first place. And number two, to properly exercise the lien so that you do not risk breaking any laws, or even if you break laws, you want to minimize the risk of exposure to liability to your clients. On the other hand, if you are representing the charterer, we would have to consider arresting the vessel to obtain security for the claims. That could involve, Thai law, or it could even involve Singapore law, because Singapore is, I think, midway, a stopping point on many vessels' routes, because it's a place where vessels go to stem bunkers. And let me kid you not, the story doesn't end there. Let's say you obtain an arbitration award in your favor as the ship owner. You have to look at enforcement of an award. You don't just look at the governing law of the charter party, you look at where the assets of the charterer is located and find out how to enforce the award best in those jurisdictions. And even at the pre-award stage, before award, you might want to consider getting attachment orders in certain jurisdictions. So I think the bottom line really is that in shipping disputes, we cannot consider things in a vacuum. We have to think globally. And that's where, my view is that an international firm like ours have an edge. We have offices in over 70 countries. Most of them are key maritime hubs. And even in places where we don't have offices, we have close contacts whom we work with. And I think I personally dare say that I work with my colleagues outside Singapore on a daily basis. And you probably wouldn't hear this from a lawyer who does things like criminal law, family law, or real estate.
That gives us a really unique insight on your role, and not to kind of take maritime law at face value, kind of developing all these liens between countries and between parties, and having arbitration awards be used on a more deeper note. So kind of speaking of global issues, how has COVID-19 resulted in disputes in the maritime industry?
Okay, it was a big hoo-ha back then in 2020 and 2021, because in shipping, time is money, and what COVID brought with it was uncertainty. It brought with it delays, disruptions, crew under quarantine, cargo operations disrupted, vessels lost deviate from the usual routes. So supply chains were also heavily affected. Now, take for example a contract for the supply of coal. If a coal mine had shut down because some of the miners got COVID-19, could the seller then invoke something we call a force majeure clause in their sale contract? And it usually boiled down to how the coal was described in the contract. If it specified that the coal was to be from a certain specific mine, the seller might have a better chance at invoking the force majeure clause. But ultimately, it boils down to, I think the name of this podcast suggests, the fine print, what the force majeure clause actually says. So yes, COVID-19 generated a lot of disputes, and the common theme in all of these disputes was really, as lawyers, we were asked to figure out, to advise on who should bear the financial losses, who should bear the extra expenses, and, who should take responsibility for all of the risks that resulted from those delays and disruptions.
That's a very valuable insight. Having uncertainty play such a big role in law might not be something that's so commonly thought of, especially in shipping law. And, having this burden of paying the financial burdens and all these other kinds of complications, it's kind of difficult to decide, who pays what. So on a more national level, interplaying a bit with your job, how has Singapore's position as a global maritime hub influenced the kinds of cases you handle?
I think we need to take a step back. We depend a lot on international trade in Singapore. If you are in the United States and if you are having a trade war with China as it is right now, you can always opt not to consume Chinese apples. But we don't have that kind of luxury here in Singapore. If you do not get Chinese apples, you can't get apples from Changi or you can't get apples from Orchard, you would have to find Fuji apples from Japan, for example, or apples from somewhere else in the world. So trade is literally a lifeblood over here. And a reason why Singapore works so well as a maritime hub is, I think, by and large, also trust in our laws, in the integrity of our dispute resolution systems, the efficiency of our courts. And what is helpful is that we are also seen as a midpoint between the East and the West, which makes us very popular as the choice of law for disputes between international parties. And I think one more thing I should also mention is that Singapore is the largest bunkering port in the world. I briefly touched on it just now. If a vessel isn't carrying goods to Singapore, it may very well be stopping by Singapore on its route to other places, especially to stamp bunkers. And that's why I think we as maritime lawyers, we are very busy with things like ship arrest and other admiralty proceedings. So whenever a new FAR lands on my desk, I think the people I should really thank would be those who made Singapore what it is today, that gave Singapore its strategic location, its trade-driven economy, and really its trusted legal system.
That's fascinating on how Singapore is used as such important global maritime hub. You know, its geographical location as well as the modernization and development of Singapore all plays a role in making this country a kind of trade hub, as you mentioned. So, taking a look at the bigger picture, how have you seen maritime law change over time?
I see in the past 10 years, it would be on two main fronts. The first would be geopolitical events. Now take the ongoing trade war between US and China as an example. US has imposed tariffs on China-built vessels calling at US ports, and the industry has responded by developing, standard contract provisions to allocate who bears those tariffs. Then let's not forget the Russian-Ukraine war also, which has brought issues like, dark fleet, evolving sanction regimes, and we are always asked to advise on rights and responsibilities of parties when one of them in a contract becomes a sanctioned entity or is designated as a sanctioned entity by one of the major nations like the US or the UN. So the second thing would be the drive towards sustainability. There's been a lot of talk about this in the maritime industry. The IMO, the International Maritime Organization itself, has introduced measures like the 2020 sulfur limits, the Energy Efficiency Existing Ship Index, EEXI, the Carbon Intensity Indicator, which basically set rules for energy efficiency and carbon emissions. And in the EU, you have things like the Emission Trading Scheme, the Fuel EU Maritime Regulation, which extend carbon pricing and clean fuel obligations to vessels which deal with EU. And I know I went into a lot of technical rules, but I think the bottom line is that they really change how risks and responsibilities are allocated in shipping contracts. We look at BIMCO publishing, transition clauses, operations clauses which define how owners and charterers must cooperate to meet these efficiency targets. And even I think a lot of contracts right now, they specify who bears the cost of emissions under the EU regime.
You've provided a really meaningful perspective on the evolution of maritime law and a really clear breakdown into two kind of major components, having, the conflict of countries on one side and as well as a rise of sustainability. So now shifting focus to something more in the future, how does technology affect the maritime industry and maritime law overall?
Okay. So actually, tech in the maritime industry happens to be a pet topic of mine, and I've also written papers about it. To me, I think technology opens entirely new frontiers where lawyers have to ask themselves, can existing legal principles be applied to new practices with new technology, or do we need new laws altogether? Take, for example, vessel collisions. We would usually see claims in the tort of negligence being brought by each vessel owner blaming the other for a collision. So when a court or tribunal is asked to determine or rather apportion liability between two vessel owners for a collision, it traditionally would consider the 1972 International Regulations on Preventing Collisions by Sea, in short, COREX. This is what we maritime lawyers refer by. But I should mention that the COREX was designed for human-operated vessels, and you would see references to terms like proper lookout by sight and hearing, and various other references to what a human on board would be able to observe using human sensors. Now, imagine fully autonomous vessels which are controlled remotely from shore. How then do we apply these same rules which were designed for human-operated vessels? And I think that's pretty tricky. And what's even trickier is the fundamental question of what law even governs the dispute in the first place. So normally we apply something called the lex loci delicti, which means the place where the tort occurs or the place where the act of negligence occurs. So if you're looking at a collision in Malaysian waters, it's easy to pinpoint Malaysian law as the governing law of any apportionment of liability, determine the issue of liability. But what if one vessel is fully automated, controlled remotely from somewhere like Singapore, and the other vessel works on sort of a hybrid system where some navigation is done on board and maneuvers to avoid collision may be controlled remotely from somewhere else, say Indonesia? Can we still say that Malaysian law would govern the dispute even though the collision happened in Malaysian waters? I don't have an answer to that. I think arguments can be made in support of whatever laws depending on what benefits your client the most. And I can only say that it's an exciting and rapidly developing area, and all we have to do is really to stay tuned and to think a little bit more and hear different perspectives on the matter.
I definitely agree. I think technology opens up a whole new sector of law, as you mentioned, that's kind of unexplored in the sense, and how just regular law these days definitely does not apply to technology, adding on to law and just kind of creating new regulations. Your example that you used was especially prominent and definitely outlined the challenges that technology poses. So furthermore, how does generative AI impact the way maritime lawyers work and the manner that disputes are resolved?
It's not just affecting maritime lawyers, but lawyers in general. It has already changed the way we work. It can handle things like e-discovery, manage documents, do legal research, and even draft standard contract clauses. And personally, to me, I think a good lawyer is one who is able to leverage AI in a very responsible manner, but at the same time also hone the very unique human characteristics that make one a good lawyer. For instance, your judgment, the way in which you develop strategies, your advocacy. It is something that AI can't replicate. But I think the message is quite clear to us maritime lawyers. It needs to be part of our strategic toolkit. Whether is it using AI to work smarter, or sometimes, using or really pointing the blame on AI when things go wrong. And this might come up in, for instance, refusing or challenging the enforcement of an arbitration award that was prepared using generative AI. So these are things that we should always be considering. These are things that we should always be alive to as maritime lawyers.
That's a very enlightening point on AI and lawyers as a whole. I think finding that balanced combination of using AI for maybe more research or analysis, however paired with the kind of human skill set needed, makes it easier into transitioning into this new phase of our world where it's more kind of globalized and more tech focused. So finally, what advice would you give to aspiring law students interested in pursuing a career in maritime law?
Okay, that's not an easy question to answer. The conventional wisdom is that you should be prepared for long hours, survive on very little sleep, you have to forgo your social life, you have to drink only coffee. And I do admit that was a very good description of how my life was as a trainee solicitor 10 years ago. And the image of success in my parents' generation was, a very busy professional wearing a suit and a tie, working in a nice office in the heart of the CPD. But I think today the image of success might very well be different. It probably doesn't involve self-torture. I might even say that it's starting to look more like a guy sitting at home in a t-shirt and a singlet, working 4 hours a day from home or even from a beach in Bali. So, and I personally also feel there's an increased value in a lawyer working smart, efficiently, flexibly, and overall being more holistic. So if you're going to put yourself in the client's shoes, and I'm going to pose this question to you, let's assume that you have two legal teams you can pick from to work with equal skill sets, okay? There's one team which is already very sleep deprived, juggling multiple caseloads over the past 20 hours in a single day, and of which they spend maybe 2 hours commuting to and fro their big offices in the heart of the CPD. Or would you rather be collaborating with a legal team which is well organized, actually interested in the matter you are handling, and not sleep deprived? They can actually spend the time and the best time of their day focusing on strategizing on your matter. Which would you prefer?
I would definitely pick the second one.
Yeah, me too. I think that's something that law firms have to look into. But for law students, if I were to offer some tips, it would be to stay curious, listen to things like podcasts like yours, read industry news, subscribe to newsletters like Tradewinds, Lloyd Maritime Law newsletter, and even check for legal updates from law firms and the P&I clubs. The other things, be open, speak with people within the industry, find out what people are doing, because you always learn something through every conversation with people in the industry. And I think the last tip I can give is this, that you should take whatever I just said with a pinch of salt, because I think everyone finds themselves in different situations or scenarios. There's no one-size-fits approach. What I say might work for some people, but for some people, they might very well choose not to listen and still find their way around towards what everyone defines as success.
I think just defining success on its own is such a powerful tool. Just kind of determining what a success looked like for you already puts into perspective that one size does not fit all. And, there's such insightful advice there. Just something as simple as reading a newsletter or just staying updated with law just helps to overall broaden your knowledge of law, and especially for law students. So that brings us to the end of our episode. Thank you so much for your time, Mr. Chan. And to all my listeners, court is now adjourned until next time with The Fine Print.